Later, when I asked her questions, Advocate Batoy then read paragraph 70 of her affidavit, which reads at page 29 of 98, we quote, "The relevant part that is there is no provision in the NPA that deals with a scenario where a DPP from one jurisdiction can exercise powers in the area of another DPP." So it is not in the Act. It is not in the policy. It is not in the directives. A DPP cannot take decisions in respect of another DPP's area of jurisdiction. In other words, the DPP of one jurisdiction cannot exercise jurisdiction over prosecutions of another. It means that a DPP of one area cannot control, direct, run with, supervise, and coordinate a prosecution falling within the jurisdiction. I suppose she uses these phrases to suggest that these phrases means you were making a decision according to her evidence.
Which is unfortunate, Chair. Unfortunate in the sense that the decisions that she's making, she's referring to, are the decisions which the prosecution team would have communicated, which the ultimate decision, which the NDPP itself would make. I differ with her in terms of the interpretation of the powers of the NDPP in respect of allocation or delegation of work to a DPP of one jurisdiction or to another. That is common cause, even as I'm sitting here, to the extent that I'm on suspension, there's a DPP sitting in Johannesburg who's from the Northern Cape. Now, a blanket characterization of that a DPP from one jurisdiction cannot do work in another jurisdiction is legally flawed. Consequently, the same scenario that in the DPP KZN, I was overseeing a matter, not the division of the DPP in KZN. It was a specific matter which my understanding, and in terms of the NPA Act, section 20 subsection 3, I think that the NDPP has got the power to delegate responsibilities to a DPP, which is not expressly excluded in the jurisdiction. My understanding is that even then, Advocate Jiva did not delegate me to make decisions in respect of the matter that was based in KZN. And I do not know how she came to that conclusion that I made the decisions, because the record is very clear. I made no such decision.
But assuming that even the prosecution team, that is the Advocate Maema's team, were delegated to make decisions, the decision in relation to this very Katomena charges were the poker charges.
Indeed.
And correct me, in respect of which only the NDPP could exercise her powers.
Indeed, sir.
Meaning, if I'm correct, that even the prosecution team of Mr. Maema, they could not alone, without the NDPP deciding, make any such decision insofar as the racketeering charges were concerned.
Indeed, sir.
So if my understanding following your answers is correct, that issue of you having allegedly acted ultra-virus because you exercised powers outside your jurisdiction fall away.
Indeed, I actually, in the initial stage of the reasons that I was asked, and then I was advancing, and even when I demonstrated to her to say, look, this was happening, even on her own. She took the matter of the cattle miner and she gave it to Advocate Kock, who was the DPP in the Western Cape, for him to have a look with the other people and the like. So if on her interpretation that is not doable, she could not have done that. I'm referring to the famous Kock report.
To Mr. de Kock's report in which you were exculpated?
In fact, no. The panel where de Kock sat with Advocate Tenga and Advocate Mamabolo, where they made assessment according to them that there were no justification for racketeering charges. But that report, of course, as I indicated, it also did not insinuate any misconduct on the part of the prosecution team or myself.
Yes, thank you, Advocate Ngcukaitobi.
Thank you, Madam Chair. Mr. Chauke, you know, we've covered a lot of ground in this exchange with the Chair. Do you still want to talk about your CV? Or are you
I can do that.
Well, we know now. We know now who Advocate Chauke is.
All right.
You told us even earlier when we
Yes.
started.
Yes. All right. So there's the first 10 pages we can skip.
Yes.
Okay, that's fine.
Thank you.
And then on the allegations, I think we've also covered a lot of this ground before, what the allegations against you are. So those 2 pages that seek to summarize the charges, we can skip. And then the background to the inquiry, I think everyone knows the background to the inquiry and the basis for the establishment of the inquiry. You may wish to say something about the opinions that appear from paragraph 47, just briefly.
Yeah. Thank you, Chair.
Yes.
Let me start with the one that is very significant of Advocate de Kock, which after the opinions of Advocate Nalane SC, Advocate Mayanecha, and his assessment, he made that recommendation to Advocate Batoy that there's no basis for her to recommend that there should be an inquiry into my fitness to hold office. I'm saying this because this specific memorandum was neither disclosed to me then or to the President when the application for my fitness to hold office was made. I'm saying this because Advocate Kock, as you would have understood, he was the National Deputy Director of Public Prosecutions, who was reporting to Advocate Shamila Bato, and who was internal with experience, and who advised her that there's no basis for her to institute. But having said that, on the receipt of that, you'll see there is an opinion of prepared by Dr. David Broughton. He's a senior state advocate in her office. I think he's a legal advisor and the like, who she asked, and even the record will indicate here that he gave an opinion, and his opinion was about jurisdiction, put it that way, in the main. It did not deal with specifically in depth about the merits of the racketeering charges. And Dr. Broughton then made a recommendation that he thinks there is a case for me to answer in respect of the Boysen matter. the so-called Katomania matter. But he also recommended that there is no basis for an inquiry into my fitness to hold office in respect of the Mdluli matter. But you will see that Dr. Breytenbach was asked to make another opinion, which was to seek to get really the reasons for her to be able to be justified to make that recommendation. Now let me get to the memorandum of prepared by Advocate Gathali SC. I'm afraid, and I'm really concerned that
just before you get there, the opinion, I'm not sure how they have arranged this for you to make it easy for you to find them. But the opinion of Dr. Breytenbach, the first opinion, which is dated the 23rd of February 2023.
Yes.
I do need to spend a few minutes with you on that one because it became the subject matter of a discussion between myself and Advocate Batoyi.
Yes.
Now that is at LO00149. LO1, yes.
00149.
Yes, 00149, yes.
I'm there, Chair.
Now, when you look at LO00163, okay, and under the heading analysis, okay, are you there?
Yes.
And the first subheading is the withdrawal of the murder and related charges in the Mdluli case.
Indeed.
Yes. What did Dr. Breytenbach say?
In the light of the findings in the SCA-FUL decision, as referred to above, no recommendation is made herein that the Section 12, subsection 6A inquiry be instituted against Advocate Chauke relating to the withdrawal decision in the Mdluli case and referring the matter charge to an inquest instead.
Now, so when you read that, what does that mean?
It simply means that Dr. Breytenbach did not see, like Advocate Kock, that there is no basis for an inquiry to be held against me in respect of the Mdluli matter.
You see, the problem is this, the statement under oath signed by Advocate Batoyi alleges that Dr. Breytenbach, she says, the reason I asked Advocate Hali is because Dr. Breytenbach did not deal with the Mdluli matter in his opinion. Is that factually correct?
It's incorrect. It's actually misleading the panel, because the record is there. And I remember exactly when she was testifying here, and when she was confronted about it, she couldn't explain.
Yeah.
She sought to say, this is not a recommendation.
Yes, no, I understand it, whatever its status is, but the fact that she says, the word that she used is that Dr. Breytenbach did not deal. Right. We can go to this. I think they've opened now for you in the statement of Advocate Batoyi.
Yes.
Paragraph 173.
Yes, I'm there.
So if you read paragraph 173, it says, on 23 February 2023, Dr. Breytenbach provided me with his opinion. He concluded that I should make a recommendation to the President regarding the fitness of Advocate Chauke to hold office in respect of his involvement with and the handling of the Boise matter. Now look at the following sentence there. He did not deal with the Mdluli matter. Can you see that?
Yes.
Yes. Now, we've now gone through paragraph 45 of Dr. Breytenbach's evidence, and we've seen what it says. So it's not about what she said, or what he said. It's the fact that Advocate Batoyi, under oath, claimed that Dr. Breytenbach did not deal with the Mdluli matter.
Which is a misrepresentation, Chair.
Yes.
Because the record indicates clearly that Dr. Breytenbach dealt with the Mdluli matter.
Yes. Now, at paragraph 176, I think it's that same page. What does Advocate Batoyi say there?
He says his opinion was based once again on Advocate Chauke's handling of poison matter, aspect of it. He did not deal with the Mdluli matter.
Yes. Now, what would you say about that?
It's a misrepresentation because the record as we have it indicates the contrary.
Yes, yes. Now, we can then deal with how he dealt with it. You haven't clarified that it's actually a misrepresentation that he did not deal with it.
Yes.
Now, the way he dealt with it was that no recommendation is made.
Yes.
How did he deal with the Boysen matter?
On the paragraph 46 of his the opinion to LO 00163 to which you referred to.
Yes.
There's thirdly there the Boysen Catomania case. The evidence which Advocate Mlocha gave at the State Conduct Commission has not been presented to me, and thus I'm not at this stage not able to comment thereon, unless further time is afforded to me to search for the evidence on the official State Capture Commission website if same cannot be provided to me by the NPA. Advocate Nalan SC had regard to this evidence and the evidence presented by Advocate Mlocha at the Mkhoro inquiry, as well as the other evidence dealt with and findings made in the Mkhoro report relating to the Boysen Catomania prosecution. Now, I don't know if you want me to deal with that or to go immediately to his recommendation in which he was...
No, I want you to deal with that up until paragraph 50 because...
Indeed.
There is a sleight of hand in what has happened here versus what Dr. Breytenbach actually recommended.
Indeed. Advocate Nalan SC submits as follows. If one reads Mlocha's affidavit to the police, together with the report of the Commission Mkhoro inquiry, dealing with the evidence of Jiba and Nogo, and his evidence at the Zondo Commission, it seems that Chauke's involvement in the prosecution was much deeper and more involved than simply acting as a coordinator. He went to the extent of asking Mlocha to sign the indictment. Mlocha refused to sign the indictment without the prosecution memo or report. The commission report suggests that Mlocha considered that Chauke was asking him to do unlawful acts. It is respectfully submitted that evidence presented at the Mkhoro inquiry and findings made in the Mkhoro report pertaining to Advocate Chauke's involvement with and role in the handling of the Boysen Catomania case support the submission being made to the President for the institution of Section 12, subsection 6A inquiry against Advocate Chauke.
Now, if you can just stop there. You see, this is where I say there is a sleight of hand. The factual foundation for all of this that he is recommending is that you tried to force Advocate Mlocha to sign an indictment. Remember that?
Yes.
Yeah. Now, that submission was made here in this inquiry.
Yes.
And I asked the evidence leader who was cross-examining Advocate Mayem to show us where Mr. Chauke is attempting to force Mr. Mlocho to sign an indictment. You remember that?
Yes.
What did the evidence leader say?
He said, no, there's no way that it's the case, and he withdrew.
Yes, he withdrew the question.
Yes.
Now, when you look at the actual affidavit of Mr. Mlocho, which is what the chair was talking about,
Yes.
at 6A/6.
Yeah.
Read everything there and read it aloud. And show me where there is a line that says, Advocate Chauke forced me to sign an indictment.
Let me read it for the record, Chair.
Yes.
I, Cyril Simpiwe Mlocho, with ID, hereby state in English that I'm currently employed by the National Prosecuting Authority as a Deputy Director of Public Prosecutions, and I'm stationed at the Office of the Director of Public Prosecutions, Pietermaritzburg, KwaZulu-Natal. On 17 May 2010 until 9 July 2012, I was acting as a Director of Public Prosecutions, KwaZulu-Natal. Between January 2012 and March 2012, while driving to Port Shepstone, I received a call from Advocate Ngcukaitobi, who was acting as the National Director of Public Prosecutions at the time. She informed me that there was a matter where, because of pressure, we had to enroll as a matter of urgency. I informed her that I would first read the dockets and make a decision accordingly. She stated that the matter was urgent. I responded that I did not have prosecutors to urgently look at the dockets. She informed me that because she was at the OR Tambo Airport, she was going to call me later. She did not call me later. A few days later, I received a call from Advocate Chauke informing me that he had been instructed by Advocate Jiba to send a team of prosecutors to prosecute the accused in the Cartomania case. He told me that there were very sensitive security issues surrounding the matter. I told him that I was going to attend the DPP's meeting at VGM on 29 May 2012. So we were going to discuss the matter further.
So if you just stop there now, in the conversation you held with him, is there anything here where Advocate Mlocho says, in that conversation, Advocate Chauke told me to sign an indictment?
No.
All right, proceed.
On 29 May 2012, I attended the DPP's meeting at VGM. While the meeting was in progress, Advocate Chauke told me that Advocate Jiba wanted to see us urgently in her office. I went with Advocate Chauke to Jiba's office. In Advocate Jiba's office, Advocate Chauke told Advocate Jiba that he can't discuss everything relating to the matter as he had serious security concerns and there was a possibility of investigation necessitating arrest or even advocates in the office of the DPP KZN. Advocate Jiba told the two of us that she had procured a legal opinion from Advocate Gerald Nel in the legal affairs section stating that I can sign the delegation for the prosecutors who will be prosecuting in the matter. She further told us that the indictment would, in terms of this legal opinion, be signed by me.
So now just stop there. Who is telling Advocate Mlocho who is going to sign the indictment?
It's Mlocho saying that Advocate Jiba said he is going to sign the indictment.
Yes. Is there anything that says it's Advocate Chauke who's saying that he will sign the indictment?
No, not at all.
Continue.
I told Advocate Jiba and Advocate Chauke that I was going to sign the indictment only if it was accompanied by the prosecutor's memo or report detailing evidence implicating each accused as individual and the evidence implicating the accused as a collective. This meeting ended. On 12 June 2012, Advocate Chauke's personal assistant, Ms. Mameki Suping, emailed me only the indictment without the prosecutor's memo or a report. I thereafter exchanged a number of emails with Advocate Chauke, copying in Advocate Jiba, her personal assistant and Advocate Tokoma Jokweni, requesting Advocate Chauke to give me the prosecutor's memo or report as per initial agreement. My acting appointment came to an end on 9 July 2012. I never had anything to do with the matter after the 9th of July 2012.
Yes. Now, let's go through that. So, according to this affidavit, is there anywhere where Advocate Mlocho alleges that Advocate Chauke attempted to force me to sign an indictment?
No, Chair.
Yes. Now we go to the underlying emails that were exchanged at the time. So these you will find under B2. So it's under the boys in bundle B2. Do you have those? I want to start at B579. You've got it.
It should be B3. B2, it's and B3.
No, you are right. It's B3. Sorry. Yes, you are correct. So start at
You say 579.
yes, because the emails are not sequential. They are in reverse. So it starts at the back and it goes forward.
What is the B number on that?
579.
Yes, I have it, Chair.
Thank you. So, if you remember the last paragraph from the affidavit of Advocate Mdluli said that Ms. Suping, who was your PA, sent him an indictment, but he says nothing about a message from you forcing him to sign the indictment. Remember that?
Yes.
Now, he says that was sent on the 12th of June 2012. Remember that?
Yes.
Now, we know that email at B579. It is dated 12th June 2012, 0129, from Zitmamiki Suping.
Suping.
Yes. And it has no message. It is just an attachment.
Yes.
Indictment Ketuman. Is that correct?
Yes.
Now, thereafter, what we get is an email from him to you,
Yes.
from Mr. Mdluli to yourself,
Yes.
where he refers to a telephonic conversation.
Yes.
Now, the telephonic conversations that were held between the two of you are recorded in his own affidavit, where he says it was Advocate Jiba who says sign the, it will be signed, doesn't say sign it, says it will have to be signed by you.
Yes.
Yes. Now, he then says, kindly furnish me paragraph 2 with the prosecutor's memo or report so that I can have a wrap-around view of the matter. The report must also have the police station and case numbers so that we can open up the DPP's file. Correct?
Yes.
So far, nothing from you says sign this memorandum. sign this indictment.
Yes.
We then look at your response, which is on the 12th of June, 5:14 p.m. at page 578. Correct?
On mine is 577. On the B bundle, B3.
Your response.
It's B0057.
Is-
577.
No,
And also us, I think if you look at the numbering council, the first email was at 00578
8.
by
Yes.
Mamiki Shuping to Mr. Mdluli, which is the first one. The second one was from Mr. Mdluli at the bottom of 577 to Advocate Chauke, and the third one on the same page, 00577, by Advocate Chauke to Mr. Mdluli.
I see. Okay, then I think the witness has the same numbering as the panel,
Yes.
and I have a different numbering. So So you say it's not 578, it's 577.
Yes, 577. The previous one of Mamiki to Mlocha is 00578.
Okay,
Yes.
no, that's
B
not-
00578.
Well, let's work on 577 because that I think is consistent with the panel.
Yes,
So that's the email from you on the same day
yes,
with 1, 2, 3, 4, 5 paragraphs.
yes.
Yes. Now, you can read that and tell me where you find any instruction on him by you, on Mr. Mlocha by yourself, to sign an indictment.
I can read the email onto the record, Chair.
Yes.
Dear Advocate Mlocha, who is the prosecutor that you are referring to? I have forwarded to you the indictment which has all the detailed summary by which you ought to be in a position to open your office file. I also forwarded to you details of the inquest with police case numbers, etc., to which you referred to Advocate Jokoma Joken for reasons that I do not follow and understand. The indictment with respect gives you the whole view of the matter. You are kindly and fervently requested to please discuss any issue, if any, with me. I really do not see any need for me to give you any report other than what I have forwarded to you already. Please, if I misunderstand you, make me understand. I do not want to play you or undermine your jurisdictional authority in any way whatsoever. There are serious issues of security in this matter, which, if necessary, you will be briefed about, which are not relevant to you, and I cannot expose such to you at this stage. I have also learned with utter dismay that you have now issued an instruction to the senior prosecutors that all dockets that are with us must be brought to you. What is not happening here, my brother? Please, if you have any issues again, talk to me or arrange that we see the acting NDPP urgently. Another issue of concern to me is the delay in you issuing the instruction of the reopening of the inquest, in view of the fact that you have been requested to sign the indictment, which must be preceded by your decision to reopen the inquest.
So I'll stop there. Now, what does that sentence mean? Because that's the only time there's a reference to the indictment, but what is it saying?
It's saying that we need to consider the issue of the inquest so that it should precede his signing of the indictment.
No, but what does it say about the indictment?
It says that which has been requested to sign the indictment, which must be preceded by your decision to reopen.
That paragraph, that passage that talks about the indictment, what does it say? It says you have been requested.
Yes.
By who?
By Jiba.
Yes.
Yes.
And then you can continue the rest of it. It's got nothing to do with you saying to him, he must sign the indictment.
Yeah. If this makes you uncomfortable, please indicate so that I may urgently take the matter up with the NDPP. I do not want to step on your toes. I was informed that you agreed and arranged with the acting NDPP for somebody from outside to do the prosecution in these matters. If you have now a change of heart, please indicate so that we may resolve it as soon as possible. Regards.
You see, this is the problem. There is no other correspondence in this case that deals with this, except what we've read so far.
Yes.
Now you have a scenario in which then we've dealt with paragraph 51, 52, 53. It goes on to 56. Yes. We will come back to cover Mdluli in full, but we are just laying the foundation now. The case of Mr. Mdluli in full, laying the foundation.
Before you proceed, Counsel, I'm reminded by my sister that this is an opportune time for a comfort break. We propose to adjourn for 10 minutes. 4 o'clock.
Thank you, Madam Chair.
Advocate Chauke, you remain
Thanks.
under oath.
Thank you, Chair.
We adjourn.
After when there is the evidence from the defense, and then that will call for you to respond, and then you will go and investigate those aspects that you think needs to be.
Yes. Okay, and then the statement by Commissioner Brown.
Statement by Commissioner Brown, DC 00945 to DC 00992, DC 00998 to DC 00999, and then statement by the Danikas cross-bundle, which is in file 14542 to 472.
Yes. Just tell me, I mean, what was your this statement became a subject of a major controversy, and but you know, when the witness finally testified, it's just nothing meaningful was put to him. What was the issue from your understanding at the time about Mr. Danikas?
The signature.
Yes.
Yes. Which was irrelevant in any case, whether the signatures was there or not. But the information about what is it that was being contained in the statement, that's what served before Advocate Jiba.
Yes.
Yes.
But I mean, what was the prosecution team's strategy around this issue?
The strategy, as I understood it then, because they always, because of Danikas having raised the issue of security and all sort of things, and that they said they are not going to identify him, that is the witness in the case, because that rendered him susceptible to security threats that he has always been sharing with the prosecution team. That's how I understood.
You know, the odd thing about this complaint that Danikas's identity was not disclosed is that if you look at another witness, Mr. Matonsi,
Yes.
whose statement is referred to at page 4 of your list,
Yes.
item 2.
Yes.
You know, it's common cause he was murdered.
Yes.
Yes. And if you also look at page 5, Mr. Begingos Ndlondlo,
Yes.
whose statement is referred to as the first item, it's also common cause he was murdered.
Yes.
You know, and so it makes one wonder why Major General Boysen was so interested in the inclusion of Mr. Danikas in the list of witnesses, when everyone knows that witnesses were killed.
Yeah, the things, as I understand it, which is natural, it's once the prosecutor decides to say this witness set danger, and to identify him to the defense without just saying, giving a statement and redacting his name and address, is precisely for that purpose. And that is the provision which is there in the Criminal Procedure Act.
Yes, yes. And then the next item is the prosecution memorandum,
Which is at B00993 to B01027. And ballistic reports of Captain Mangena is 2A1 to 2A338 of Captain Mangena's statement.
Yes, why have you not included the ballistics of
Mr. Stale.
Mr. Stale?
At the time when I considered the these ones, because this to me the ones that I was submitting when we were doing when we were defending the review application by.
Yes. No, in fact, my junior corrects me that the reports by Mr. Stale were part of the annexures in the Mkiza application.
In the Mkiza application, yeah.
Yes, yes. So which actually covers what I was asking you about. Yes. Now, these documents, I mean, they are obviously taken from various parts of the dockets, but they are the key. Well, are they the key in racketeering?
That's what I'm indicating. That's why even the name there on top, I'm naming them as such. That the heading, the document considered by Advocate Chauke in respect of the racketeering charges.
Yes, yes. And
because this is where when we had to defend the review application for certificates to be set aside.
Yes. Now, I mean, understand there are two stages to it. The one is at the time a decision is taken to indict.
Yeah.
So that's all of the things you were looking at in May and in June, where there's a draft indictment right up to the 17th. Then the indictment is then prepared and served. Right? Now, when was the review brought by Major General Boyson?
You can just help me with the data.
Yes.
Just don't necessarily have the
I
data.
think it was brought the following year in April 2013. I think we will find it now.
Is it not May 2013?
It could be, Madam Ramakaka.
Somewhere during the start of the year 2013, thereabout.
But what? All right. Turns out my memory isn't that bad. 13th April 2013. So,
Thank you, Chair.
yes. I apologize, Madam Ramakaka, on the Olympics of memory. Yes, so it's brought in April 2013, but I understood that prior to this being brought, there was in fact a request for further particulars.
Yes.
Can you remember that?
It was when the case was transferred from the regional court that was going to be transferred to the High Court.
Yes.
I think when it made appearance there, they filed the request for further particulars, which the prosecution team was responding to the defense and back and forth. And then after the prosecution team, as I understand it, had submitted the further particulars, that's when the accused through Mr. Boys and lodged the review application.
Yes, and the response Mr. Mayema spoke about, and I think the document we have it somewhere is about 200 pages long.
Yes.
All of the further
The way he
particulars
was dealing with the further particulars that were filed.
And then the review was then brought.
Yes.
Now, you remember that one of the issues that are taken, we've now covered what you were looking at prior to the institution until August 2012. Then the review is brought in April 2013. You have to assemble together and defend it. Now, the charges against you here, or the issues to be investigated as per the terms of reference, also criticize you for the role you played in defending the review application.
Yes.
How do you defend yourself there?
The acting NDPP, they had taken a decision that the application for review, even on the advice of the prosecution team, who felt strongly that there was a case. That's what happened.
Yes.
That the defense of that review would never been undertaken if the acting NDPP then would have decided otherwise.
Yes. So the decision to oppose was taken by the acting NDPP.
Yes.
Yes. Well, you know that we looked at the Advocate Mayema's delegation of authority,
Yes.
which entrusts him with the authority to oppose not only reviews but appeals,
Yeah.
and also institute
Yes.
reviews and appeals.
Yes.
You know, so he had authority to do it.
Yeah. Well, the application, the notice of motion was against the NDPP.
Yes.
So even if Mayema had the delegation to oppose, obviously it would have been with the concurrence of the respondent, who was the NDPP.
Yes. Anyway, your point is that the decision is taken not by you but by the NDPP.
Yes.
Yes. And then what role are you assigned there?
As the coordination, she has to prepare affidavit. She has to file the opposing affidavit, and I got into that, and I advised liaison with Lawrence Orders with all the documents as I listed them here. That which I had to consider, got them from the prosecution team, gave them to advocates Lawrence Orders SC and Advocate Manaka. They drafted, they shared the draft. I shared the draft with the NDPP, corrections here and there, and then take it back and forth and said it. I settled it on her behalf and then sent it to her, and then she signed.
Yes. I mean, it comes back to the point I asked earlier. I mean, what exactly is Advocate Batoyi expecting would happen? There is a big case launched, and it's against the NDPP. But there are many cases against the NPA. So she has to rationalize her time. So it's either she attends to this case individually, or she assigns a person that she trusts to look after it. In this case, she asks you.
Indeed.
And what are you expected to do? Just say no.
The expectation with the narrative that I understood it looks like as if when Advocate Chiva in the capacity of NT people would have delegated people, those was seen to be state capture and whatever. But when the others will do exactly the same thing to delegate is very normal, including herself, Advocate Shamila Batoyi.
So, so what attaches to this criticism is this notion that, well, the affidavit contained falsehood, mendacity, etc., and you are part and parcel of that. We've looked at that. We've shown that actually the foundation to this entire thing was a flawed foundation.
Indeed.
Yes. Now, before the review, there were certain other, I would say, incidental decisions that you were involved in. Now, there are two that I'm interested in. The one is the centralization. You remember the whole issue that, why is Advocate Chauke signing centralization? And now the reason why centralization became important here is because these Keitomano police followed a man of one of the Ndimande brothers to Reinstating, and they killed him in his flat. And the question had to be made by the DPP of Northwest, Mr. Smith, to prosecute or not to prosecute. He issued a nolle prosequi, after which it was it rescinded, that nolle prosequi. But then there was a request that all of these must go to KZN, which is where we see your signature there. But can you just explain yourself there?
No, inadvertently, as it were, I should not have signed the application for centralization to Johannesburg using the letterhead of Johannesburg, because that was supposed to be done in the name and direction of the DPP KZN. And once that mistake was realized, that was where you're talking about recession and whatever, to correct what was supposed to be wrong. And I accepted that one made an omission there, and it was not supposed to be made by me, because those that were in respect of my jurisdiction, the one which was in Don Park and Jimmy Stan and they were still not added there, and I was not going to have to consent to them, because I was going to consent in respect of those, for them to be centralized in KZN as well.
Yes, no, but can you give just a narrative of what actually happened? So this whole thing happens after the 17th of August 2012.
Yeah. So Advocate Mayema has prepared this draft request, and then he asked me to sign them. Now, when I signed them, I think Advocate Musing or Advocate Smith picked up that the letterhead it's coming from Johannesburg, not necessarily from KZN.
Yeah.
And that's how Advocate Mayema went back to correct that.
Yes, the reason for that is because at the time, Advocate Mayema, according to him, is working in your office.
Yeah, I was sitting in my...
Given them space.
Yeah.
And then what they do is they use your letterhead to type.
To send out correspondences and that, which in this instance of centralization, they couldn't, because in terms of submitting a memorandum or something that the NDPP wanted, it was no issue. I could send it under my letterhead because it was of no consequence. Yes. But this one, which in terms of statute and the like and jurisdiction, it had to be done under the letterhead of the DPP case.
Now, there was some issue raised with the advocate. Yes.
Get there. I'm sorry to do this once you've begun to ask your question. But I just want to clarify, Advocate Chauke, on this issue of centralization. You are speaking about two documents, the one that had been drawn on the letterhead of Gauteng South, and then the subsequent one that was then drawn from the KZN. What you should inform us about is as to on which application of the two, on which application did the NDPP act? Of which one?
I think she acted on the strength of the corrected one. Yes.
Thank you.
Yes. Thank you very much. So there was an issue raised by the evidence leaders around what is the significance of the signature appearing in a document. Are you taking ownership of it? Are you not taking ownership of it, etc.? That was asked in relation to Mr. Mayema, who says, listen, I drafted the document, but I have no access to the NDPP. The person who has access to the NDPP is Mr. Chauke. And so I'm drafting it in his name, and I'm expecting it to send it on my behalf. And then they look at the memorandum, they say, well, the memorandum doesn't say it is being sent on behalf of Mr. Mayema by Mr. Chauke. So I just want you to take us through how actually you worked with this prosecution team.
Look, let me give you an example. They prepared the presentation, and the presentation must be sent to the NDPP in a meeting that would have arranged, as I indicated. They will give me that presentation. I will send it under. They will type a letter under my letterhead, and then I'll send the presentation to the NDPP. All right. Now, in terms of the decisions, as it were, once they would have made that decision, the natural thing is suppose that if it's a recommendation about the decision to prosecute, the letterhead that was supposed to be used, the letterhead of the DPP KZN. And which you would have noticed when Mayema testified that he asked me to PP for advocate Nock. So that is the difference. But in most of the presentations that the meetings that I refer to here, all those presentations I sent them from my office letterhead, because it had nothing to do with that you are recommending a prosecution or not. It was information that had to be conveyed to the NDPP. Yes. Yeah.
I mean, I suppose there was an element of trust as well, that no one will abuse a letterhead of the DPP South Gauteng.
No, of course. These are seasoned prosecutors, especially Mayema. Maybe I had this advantage that when I was a senior state advocate in the DPP's office, we were together the senior state advocates in that office.
Yes. Yeah. So when he puts something in front of you and he says, Mr. Chauke, we've decided as the prosecution team to send this to Advocate Jiba. Yeah. It's not like you sit down and you say, no, I'm questioning you. You sign it, you trust them.
No, really. As colleagues, you start from the question of tapping each other. You can't second guess each other. Yes. If we were to do that, the work strains is going to suffer.
And similarly, when this error was made, it's not as if it's an error that is picked up by a stranger. It's picked up inside the team, and it's internally corrected.
Precisely.
Yes.
And that error the decision maker did not take issue about it. She understood then that there was error. The NDPP who replaced them, Mr. Ngasana, did not think you have to make a meal out of it. Equally, the advocate Sean Abrams did not take issue about it either.
I mean, I think that there's a difference in somebody picking up later that you made a mistake and you picking up that you've made a mistake and then correcting it on your own.
Yes.
You know, because it's all showing that everyone is acting in good faith.
Of course.
Yes.
Bearing in mind that all these issues we are talking about, insofar as the Katumena matter is concerned, we are dealing with the poker racketeering provisions.
Indeed, Chair.
Even if you signed and you didn't pick up the error, why then does it seem to be an elevation of form over substance? Am I right in thinking that way?
Indeed. That's why I'm trying to explain, to say, look, there were 3 NDPPs. And then 10 years later on, another NDPP says, no, look, this is something, it's done with malice, it's done with all sort of things, and like, which is just unfortunate.
Because what troubles me, Advocate Chauke, is that this case has become such a big case, and yet the terms of reference should be guiding us. You explain in your affidavit from paragraph 6, and you deal with this critical aspect of the terms of reference, a decision.
Yes.
If we find, and I need to be held there, if we find that the terms of reference, insofar as the Katumena matter is concerned, paragraph 3, the entire of paragraph 3, none of those things referred to, the supporting, the recommendation allegedly made by you, the defending of the review application, the appealing against the decision of Governor J, and any attempt to reinstate those charges. If we find that those things, given the fact that these are racketeering issues within the context of poker, doesn't this fall on the wayside?
Indeed, Chair.
If we find that these things don't constitute a decision, a prosecutorial decision, because neither you nor Advocate Mayema or his team could make such decisions, but only the NDPP. So if you find that these alleged conduct on your part do not constitute a decision, what then remains?
What remains there is that there is no basis for the charges as they stood, or the allegations as they stand now.
Because the case has proceeded on the premise, as I understand it, that there was no decision, and I stand to be corrected, Advocate Ngcukaitobi. But then your case went further to gather evidential material to prove that, in fact, there was evidence that justified the institution of the racketeering charges.
Yes.
Is my understanding correct?
Indeed, Chair. My understanding, your understanding is exactly as I understand it, that if there is indeed evidence that there is a case that has been committed, that should be the end of the matter.
So the point is, there is no decision that you have taken, according to you.
Yes.
And if there is no decision, do we even consider the evidential material?
No. To the extent that I accept and I know that I supported the decision, as it were, in terms of me having to send the documents and then prepare these documents to Advocate Jiba and whatever I'm saying, still that does not make me a decision maker.
Yes,
Yeah.
that's what I'm trying to probe with you. But I'm saying, once you have crossed that hurdle, the first hurdle of determining whether these things that the terms of reference speak about do not constitute a prosecutorial decision in the context of racketeering charges in terms of poker, then what remains of these claims against you?
They have got no merit, and that's why I as advised that one had to make that point in the opening statement that you're charging a person who did not make any decision.
What then remains is, even if we assume in the favor of the NPA that you participated in a prosecutorial decision,
Yes.
that is, having crossed that first hurdle, the allegation that there was no evidence is flawed.
It's fraud. It is without merit.
Yes, because what we have been about was to gather information that says, here is the evidence that justified the institution of the racketeering charges.
Yes.
Is my understanding correct?
That's very correct, Chair.
Advocate Ngcukaitobi, are you helping me to understand
Yes.
how?
Yes.
Because this has been,
No.
I thought that we have so much in front of us, and I'm not sure what we are now pursuing. I thought that we should really focus on the terms of reference.
Yes, no, Madam Chair, you are correct. There's just one issue that Junior wanted to bring to my attention, which to conclude that part about the centralization. It's the document at B01254.
B?
At B5.
Is it in the list that you have just submitted to us?
No, apparently not, Madam Chair.
Should it be included? Should it be included?
Yes, I think we should include it.
Before post-review period?
Before the, yes, it's 27th August. Yes, it would be before the review period, yes. I should find it here. It's B01254.
I have it, Chair. It's the one that is addressed to from Advocate Muslim to Advocate Jiba.
Yes, no, yes, it's relevant in the context of the answer you gave, which was the actual decision maker, who was Advocate Jiba,
Yes.
is the person who was deciding on centralization. What was going on between the DPPs was which route it should take? Not that the DPP will decide, but which channel will be followed? Is it the channel of Johannesburg or the channel of KZN?
Yeah. The issue there being that the issue that is being taken there is a consent of the DPP of its jurisdiction is required.
Yes.
So if I'm not the DPP of KZN, I can't issue a consent in respect of.
Yes.
Yeah. So if the offences were committed in Johannesburg and they needed to be tried in KZN, I needed to issue my consent, which must go to the NDPP for the NDPP to issue the centralization.
Yes.
So that is what is being made. That I can't sign a consent to say I consent as the DPP of KZN that the offence committed in KZN should be done in Northwest and vice versa.
Yes, but the point you're making, though, is a slightly different one, which is the decision maker didn't make an issue of the error that had been committed in the previous document.
Exactly.
Yes, and this is what is here.
Yes.
That's where he says, Advocate Musing says, a directive in respect of the above-mentioned provisions have already been approved and signed by you in the above matter in respect of the offences committed within the area of jurisdiction of the DPP Northwest. However, the application was erroneously submitted under cover of a letter from the DPP South Gauteng instead of DPP KZN. A new request has now been submitted under cover of the attached letter from the DPP KZN dated 20 August 2012. It is requested that the acting NDPP issue a new centralization directive as per the attached draft.
Yes.
It is notable that the concern from Advocate Smith SC is directed to the DPP KZN. The facts are otherwise unchanged.
Indeed.
So when you picked up the error internally and you asked the decision maker, here it is, no one said, Mr. Chauke, go to a disciplinary hearing over this.
Yeah.
It's now coming now here that you should be disciplined over this.
Yeah, that's why I'm saying that other than that Advocate Jiba would have accepted that correction. The others who followed as well did not think that there is anything untoward about that.
All right. Can I ask you? Sorry, finish.
But sitting where I'm sitting now, and the narrative, like indicated, you would have seen once we come into some, when we go some of the opinions, you see there's a specific opinion that is a source of this set capture things, other than the other opinions, and then again, that's where lies the problem.
Well, I mean, there is one opinion that talks about state capture. It's
Yes.
from Advocate Halley.
Indeed.
Yes. But state capture has become irrelevant, Mr. Chauke, because I asked the NDPP, do you have evidence of state capture? She said no. So let's forget about state capture. It's irrelevant.
I understand, Chair, but unfortunately, I'm sitting here because of state capture.
No, but it's irrelevant. There's no point in you repeating state capture. Because the person who brought the charges, I confronted her, she said no evidence of state capture. So whatever opinions from Mr. Halley are irrelevant.
I take the point,
Yes,
I take the
right.
concept.
Okay, so no state capture again.
Thank you.
Thank you.
My
very
apologies.
much. Thank you, Advocate.
My apologies.
Advocate Ngcukaitobi, thank you. I've been resisting the temptation to raise this issue. In every sentence that comes, I say, I hope I'm not going to hear it.
Sorry, Chair.
You
I
have
accept.
understood it,
I
right,
understood.
thank you.
I take the point.
Yes, all right. Now, can I ask you to take your terms of reference again? Let's just do this exercise.
Now that you're going there, where I read and really concerned about council, now that you're going there, there's a catch. The catch-all clause there in 3.1. I don't know what you understand that to mean. 3.1 of the terms of reference. Then I'm sure council will take you through that so that you can help me. We dealt with this aspect when Advocate Batoi testified, but was left no wiser. So perhaps we will understand better from you, and further witnesses will come and testify. What did you understand 3.1 to main.
So if you have, is it easier to get a hard copy? Or
Yes, I actually had it. I don't know. I just misplaced it. I came with 3.1, Chair.
You,
Okay,
can,
there's
Read.
this
you
one.
can look at that hard copy from our researcher.
All right. So it's on page 3 of the terms of reference, and the sentence starts with the fitness of Advocate Chauke to hold office as a prosecutor in the prosecutorial services, in particular in the capacity as a director of public prosecutions, insofar as it relates, 3.1, his direct or indirect conduct of Advocate Chauke relating to his fitness and propriety to hold office based on information, including but not limited to matters related to the following allegations. So I think the question is, what do you understand the direct or indirect conduct relating to your fitness to hold office?
That the conduct, whether I did it directly or indirectly in supporting or otherwise recommending the issuing of the racketeering certificate.
Can I ask you a different question?
Yeah.
What is direct conduct as far as you understand it?
Direct conduct. Maybe let me put it this way: that I say physically that here is my view, my recommendation that this should happen. The other one is that which it will be inferred to say, in fact, he did not do it directly. It was done. He used someone to convey this particular message. I'm trying to simplify it in that sense.
But that is also still direct conduct.
Yeah.
Both of those are direct conduct.
I try to make sense and understand what is being conveyed.
And then what is indirect conduct?
I really find it difficult to explain what indirect conduct is, except that, as I say, you would let's take the facts of Catomania in respect of Mr. Boysen, that says he's not on the scene, but is able to drive and direct what should be happening at the scene.
No, but that's still direct conduct. He's giving the instructions.
In that sense,
I mean, the law
unless
usually
if
makes
it's intended to convey an insinuation of malafide.
No, but it's conduct. It's not motive.
No.
Now, because the law usually recognizes either conduct or an omission,
Yeah.
but conduct is conduct. And omission is where there is no conduct, but you should have acted, but you failed to act, and that's where you've omitted.
Yeah.
And there's liability attaching to conduct and liability attaching to omission, where there is a legal duty to act and you fail to act. What is unclear in law is what can indirect conduct be?
I read my understanding there was that this the direct and indirect will amount to one and the same thing, but I'm trying to understand and describe it positively as opposed to negatively.
No, but what is the positive description?
That the direct and indirect means one and the same thing.
Yes, all right. But I mean, your statement says these charges are vague and embarrassing.
Indeed, that's what I was trying to indicate in my
And
my
the
opening.
embarrassing part simply means you don't understand what they mean, and therefore you cannot respond to them.
Indeed.
Yes.
So you understand the difference now?
No, I understand the difference.
Okay,
That's why, Chair, I was indicating that to me it would have been one and the same thing, but absent any explanation and, about that. I accept that, and on the advice which I accept. That,
You align yourself with
Yeah.
what he says. Thank you.
Yes.
All right. Thank you. And then based on information, and then there's another ambiguity, which is including but not limited. Do you understand what that means? Because if you're going to go to a hearing, you need to know the scope of what is alleged against you. Where does it start? Where does it stop? Now, a phrase like including but not limited seems to imply unlimited liability in time and in scope.
That if I'm sitting here and somebody out there thinks that I must go and say something about Chauke did 15 years or 20 years ago, it should come into this forum. That's I don't say mischief. That's how I see that this is coined to be able to open the wider net. What in criminal prosecutions say, we throw the book at the accused.
Yes. And does that explain why throughout up until now, we still don't know the full scope? Because sometimes you've signed a prosecution, you force someone to sign a prosecution memoranda. Sometimes you force someone to sign a docket. You know. And then sometimes the problem is the centralization. You just never know because these charges are a moving target.
Yeah. At times, the description of when you say you're arranging with the JP, which court, that's a prosecutorial decision.
Yes.
You're deciding to prosecute when you arrange a court.
Yes. And then they keep questioning you about exceeding your jurisdiction, but it's not in the charges.
Yeah.
Because they've done this unlimited scope.
You will understand, as I understood it, that's why there was an attempt to say that the terms of reference must be amended to be in line with what is now being presented.
Well, after cross-examination.
Precisely.
Which is very convenient.
Yeah.
Yes.
Well, if you look at, we dealt with this during the evidence in chief of Advocate Batoi, because we really wanted to understand what this part of the terms of reference means. I'm looking at the transcript here, where Advocate Batoi said the following, and you may comment if you wish. Chairperson, if I may at this point explain that paragraph 62.3 refers to taking prosecutorial decision whether to prosecute or not. My evidence will include the fact that a prosecutorial decision is not one that is limited to whether to prosecute or not. Your comment?
Precisely, that's the point that I was trying to make, that it's opening a wider net so that if you can't get this, you should be in a position to rely on this. Because once you say you're talking about organized crime, racketeering charges, that wording is actually saying you can also bring any other thing that does not relate to what is in here. And that's why there is an issue of jurisdiction, when in fact it's not even an issue. But you, as I understood it, the first 5 days or 6 days of the testimony was about jurisdiction.
Yes, but the point is that this answer does not seem to address the fact that we are dealing with racketeering charges here.
Indeed.
It seems to be answering just a general question in a criminal case.
Yeah.
Am I correct?
Yeah, indeed correct.
Further, we referred to Advocate Mlocha's point in his affidavit that he did not want to sign the indictment because he had not been provided with the memo and the dockets.
Yes.
And Advocate Batoi says, precisely, Chairperson. Then I asked, yes, but that begs the question. Does that impact on the terms of reference in relation to Advocate Chauke's direct or indirect alleged indirect conduct? And she answers, Chairperson, if you go to the terms of reference, this aspect of the evidence will relate specifically to, and then let me, if I may explain something. I know I have been asked to keep it short, and I really do, but I want to try to help. I want the panel to understand the circumstances. So these terms of reference were drawn up. It appears that it was taken primarily from my letter that I sent to the President recommending an inquiry to be held. The terms of reference were not discussed with the NPA, but it was taken from there. So we still don't get an answer as to what this part of the terms of reference really means. And when you go back to the question of a decision, prosecutorial decision, I still battle to understand what this aspect covers. And it seems just to be a wide clause, and we have not been presented with evidence, at least so far, that seems to support this allegation under the Kock provisions.
Indeed, it's unfortunate, Chair, that that's what it is. But if one looks at how we understood the process that led to the drafting of this, it's confirmed on record that it was drafted after the opinion which was making reference to. I'm no longer going to use that word. So in that opinion, there's confirmation that on this terms of reference were settled by Advocate Hali on behalf of the NPA.
Yes.
So my understanding was to try and widen the net, that if we don't get you here, we must get you here.
Yes, I see Advocate Ngcukaitobi tried also to assist there. Can I also assist you? The charge itself limits the factual basis to the finalization of the answering affidavit. It does not include any other thing. Advocate Ngcukaitobi, if I may on that point say that I don't know what you say, the chapter on these charges, if you want to call them charges, for want of a better word, states at 3.1 that I've referred to, his direct or indirect conduct should be direct or indirect conduct of Advocate Chauke relating to his fitness and propriety to hold office based on information, including but not limited to the matters related to the following allegations. And my point is that in as much as this attempt to set out or do set out conduct of Advocate Chauke in this context, it is not limited to this. So I still don't know what this part of the terms of reference means, and because we have to make an assessment based on this aspect of the charge as well. And probably the evidence leaders will assist us when they call any other witnesses, if there is evidence, to support these very allegations in the terms of reference. Anything else that follows under 3.1, those specific aspects have been addressed. But it is this kind of a catch-all clause in 3.1 that I struggled with. Hence the questions to Advocate Ngcukaitobi, but I still find it difficult to understand. Advocate Ngcukaitobi, maybe you would understand it better.
Yes, well, Madam Chair.
Not.
All I can say, Chair, is that I understand, and I look forward to the evidence leaders taking issue with me about that.
Yes, Council, is your understanding maybe better than my understanding? I struggle with this concept.
Yes. Madam Chair, the only thing I was going to suggest is the actual cross-examination on this point is illuminating. I hadn't actually realized that it's as useful as it is. Now, because what let me just go to, I think it's day 14. Yes. What page? At page 48. Where does it start? The first question.
The 8th of December 2025.
Yes, Madam Chair. Yes, at day 14. So if we go to at the bottom of that page, so it's line 20. Yes. So I asked Advocate Batoy, well, this is what I'm debating with you, Advocate Batoy. What is the indirect conduct that is referenced? So that was the question. She then says, so I need to think about all of the evidence that I have provided thus far. So I then continue. Okay, but I'm asking you, I'm putting to you that the charge 3.1.1.3, you are saying the answer to me, no, look at the indirect evidence. And I'm asking you, what is the indirect evidence? She then says, with all due respect, I did not say look at the indirect evidence. What I said is that I was reading out the chapeau, that's like the introduction. And I said it states including but not limited to matters relating to the following allegations. My point being not about indirect conduct, but about the fact that the allegations are not limited to what is set out in 3.11 until 3.115. That was the point. Then I say, now, what are the other allegations that are not included? What do we not have? Then she says, well, for example, the allegations relating to the signing of the Advocate Chauke's request for Advocate Mdluli to sign the indictment. I said, no, please. Then she says, that should have been included here. I said, please, Advocate Batoy, we are at 3.1.13. At the stage at which Major General Boyson is in court, the NDPP is filing an answering affidavit. The charge tells us that its scope is the finalization of the answering affidavit. You are resisting my submission to you that the scope is limited. You are saying it is unlimited. I'm asking you, what are the other facts that support the defense of that review application? And then she says, I do not know if there are any other facts. That's why. So where we ended the discussion is when she said she just didn't know herself. So I don't think anyone will ever know. And because the first witness of the evidence leaders is Major General Boyson, I don't think she'll educate us more about the terms of reference.
May I just come in here? Advocate Chauke, when much as at the end they have that, a catch-all phrase where it's clear that the list is not closed. But if we are to focus on the reason for Advocate Mdlulu's refusal to sign the document, it is quite clear, and it's a closed list, ne? And it says Advocate Mdluli refused to sign the letter in the absence of only two or either of the two, and that is either the prosecution memorandum or the original case dockets. So as far as that requirement of the signing or the reasons for not signing, we have a clear enclosed answer. It's not an open-ended answer that we get. Are we in agreement about that?
Yes.
Right, thank you. Thanks.
Thank you. If we then proceed from there, 3.1.1 talks about the institution of the racketeering charges in terms of Section 2, Section 4 of POCA against Major General Boysin and members of the Nkcukaitobi unit, and the defense of those actions in subsequent review proceedings brought by Major General Boysin to have the racketeering certificates set aside. Now, the institution of the racketeering charges, whose decision is that?
It's the NDPP.
Now, and then the defense of those actions, I presume this means the review in court. Whose decision was that?
The NDPP.
Yes. Now, then they try and set this out. 3.1.1.1 supported a decision to prosecute the accused, notwithstanding that there was no evidence justifying the decision. And he sought to improperly have the acting director of public prosecutions to sign the case dockets and or prosecution memorandum detailing the alleged evidence implicating the accused on which the decision to indict had to be made. So if we look at the first one, the evidence of Mr. Mayema is that he is the one who recommended the decision. And in fact, he goes further, he says, it's not Advocate Chauke. And you know the interesting thing is that he is never cross-examined on that point. What is your testimony on this supporting a decision?
Like Advocate Mayema indicated, I would, in the coordinating role, be able to understand this is the case all about. But no,
Mr. Chauke, what is your evidence on whether you supported the decision or not in the light of the evidence of Mr. Mayema?
I did not.
Yes.
The person who supported is Advocate Mayema on behalf of with the prosecution team.
Yes. Now, then there is another issue here. You sought improperly to have, that's Mr. Mdluli, sign case dockets. Did this happen?
No.
Then there's another thing here that you sought improperly to have Mr. Mdluli to sign a prosecution memorandum. Did this happen?
No.
You know, the oddity about this is that Mr. Mdloli's email says he never got the prosecution memorandum. Now you have a charge that says you tried to force him to sign it.
Remember, the discussion between me and Mdluli is about him signing the indictment, not what is being set out here.
Yes, but I'm saying that he said he didn't have it.
Yes.
The charge is that you said he must sign it.
Yeah.
But how does he sign a document that he doesn't have?
Precisely.
Yes.
Because in terms of that email, is that he was requesting me that I must provide him with a
Yes.
prosecution memorandum.
Then you are being charged for saying he must sign it.
He must sign the prosecution memorandum.
Now, they tried to change this through the evidence of Advocate Batoyi. They said you tried to say he must sign an indictment.
Yes.
But then it fell apart when Advocate Mutsweni withdrew the question.
Yeah.
Yes.
That's when the testimony of Advocate Mayema.
Yes. Now, then 3.1.1.2, you recommended to the then acting National Director of Public Prosecutions, Advocate Jiba, the application for issuing a racketeering authorization in terms of Section 2, subsection 4, whereas there was no evidence justifying the institution of racketeering charges. Now, what's your evidence on this? Again, in the light of what Advocate Mayema said.
The prosecution team recommended the application, and I forwarded that recommendation to the.
You know, the strange thing is that Advocate Mayema said that and then was not cross-examined on this.
Yes.
Yes. Now, then there is this thing about no evidence justifying the institution. I mean, is there any person who is reasonably in their head who can say, after having listened to the 3 months of evidence, that there is no evidence for the justification of the prosecution?
Chair, what I could read from this is that the people, Special Advocate Batoyi and others, they did not necessarily read the actual evidence.
Yes.
They relied on what somebody would have told them. Because if they themselves had taken the time to go through the statements or the dockets, even 1 or 2 dockets, they would have realized that this assertion is not necessarily stand the scrutiny of justification.
So there's no reasonable person who can say there's no evidence.
No, not at all.
Because we are told that there's Mr. Major General Boyson is coming to give evidence apparently for 8 days. Now, what is the relevance of a witness who's an accused in a decision, making a prosecution decision?
I'm surprised, and the majority of the NPA prosecutors, most of them, they're asking to say, what is it that the NPA goes out of its way to defend an accused person?
Yes.
It's really the prosecutors. Most of the people who understand what we do as prosecutors, they are surprised. What is it that is in this so-called Katomania case that the NPA goes out to defend an accused person?
Yes, but isn't it something beyond that? It is the NPA relies on its case on a person who is an accused, who was an accused.
Precisely. As if he was going to say, you charged me correctly, please prosecute me.
Yes. But if you were to make a decision to charge a person, I don't understand. Would you go and ask them, are you guilty or innocent?
This is what the NDPP has done.
Yes. No, I think we can't do that. Yes. You see, because that's what I really just struggle to understand, is that if every potential criminal in this country was asked by the NPA, go to an inquiry and say you are not guilty, where would the NPA be?
Worse still, it's how many cases are we charging people, and then they go to court, they get acquitted, or they go to court, they on review, they succeed. Yes. Why have those not been complained of, and then inquiries in respect of those prosecutors or DPPs instituted? Yeah. Well, there is something in this one, there is something more than what it's being presented here.
Yes. But if that happens, that will have a chilling effect
Indeed.
On the prosecutorial discretion.
Indeed. And the prosecutors, some of them, they're even afraid to make decisions now against the background of what's happening. That it looks like when you make a decision that is not in accord with the current leadership, then you are likely to go through a misconduct. Yes. And it's problematic because that is no longer prosecutors exercising prosecutorial decision without fear, favor, or prejudice.
Yes. Now,
well, at least here, you have told us, and we are yet to hear further evidence. You have told us that you did not make any prosecutorial decision.
Indeed.
And Advocate Maema, as evidence, corroborates that. Am I correct?
Indeed.
Thank you, Madam Chair. Then,
yes. We're talking about the prosecution and responsibilities and obligations.
Yes.
Now, Advocate Batohi told us that a DPP has a duty to prosecute if there is a prima facie case and if there is no compelling reason for a refusal to prosecute. Now, this duty, is it correct to say that duty also lies with the NDPP?
Precisely. And the scale is even higher than when you refer to an ordinary prosecutor.
Okay. Now, looking at the facts and the evidence that is before this panel thus far, would you say that there is prima facie case on which these cases complained of should have been prosecuted? And I'm asking this in particular with reference to the Boyson's case. Now,
there is overwhelming prima facie case against General Boyson and members of the Katomani.
Advocate Chauke, you're teaching me something overwhelming to my Okay, if for the purposes of this inquiry, maybe one should adopt that. Now, if there is overwhelming prima facie, or rather, let's drop that overwhelming out of the engagement. If there is prima facie case or prima facie evidence, would it be proper for the NPA, and when I'm talking about the NPA, I'm talking about the entire prosecution,
Yes.
be it at a provincial level or what, would it be proper then not to prosecute the case if there is prima facie case?
No, it's very improper. It's not in the interest of justice. Once you get to a prima facie case, it says you should prosecute unless if evidence when you have made the decision comes to the fore that indicates that your prima facie case is no longer sustainable and the like, and that's why you have to reconsider decisions as and when you proceed.
But in her case, she actually explained that unless there are compelling reasons for refusal to prosecute. And I remember talking about in cases like where maybe the parent has
An
knocked
accident,
out,
where a
and so
parent will
forth.
have run over a child
Exactly.
without when she's reversing a car.
Those are examples that she gave. But in this case that we are now talking about, especially with regard to the poisons case, are there any compelling reasons that you are aware of that have been advanced for the decision of the NDPP to then withdraw the charges against the general poisons and co-accused?
I'm not aware of any. In fact, I have not seen, even on record, where General Poison has made written representations to the NDPP for her to consider this matter.
Who bears the onus to show that there are compelling reasons for this position to be taken, a position to withdraw or not to proceed with the matter?
The accused persons through representations.
Thank you, sir. Thank you.
Thank you, Madam Amakaka. Now, so we've dealt with 3.1.1, 3.1.1.2. 3.1.1.3. Now, it's talking about you sought to defend the institution in the review proceedings brought by Major General Boyce. Now, who took the decision to defend the case?
The acting NDPP, Advocate Jiba.
Yes. And then you finalized the answering affidavit of the then acting National Director of Public Prosecution in the poison review proceedings in opposing the review application, notwithstanding that there was no evidence justifying the institution of racketeering charges against the accused. Now, the case here, it seems to be that you defended the decision by assisting the NDPP to prepare an answering affidavit. Can you just explain that?
No, the counsel appointed in the matter is Advocate SC and Advocate Manaka. They prepare the opposition to the application, discuss it, show it to Jiba. Jiba says no, help finalize it with the legal team for us to be able to say this, and I get into the nick of things. I sit with the council. They send me. I send my comments and the like, and then I send it to Advocate Jiwa, say, I'm satisfied, this is what is coming from council, and it's in accord with what has been presented to you for the decision that you have made, which is now being challenged. And she was happy. She signed the...
You know, the problem is, you see, whenever you see something called misconduct, it's usually deviation from expected standard or expected conduct. What I can't work out here is what were you expected to do? There is a case brought against the NDPP. The person cited nominally is the NDPP. She then says, Mr. Chauke, please assist me to draft the application, to draft the answering affidavit, which you then do with the advocates on the brief. What on earth are they saying you should have done?
It's because it's Jiba. You should not have done it.
No, but I'm saying from your perspective, what were you expected to do? What is the expected conduct when your boss says, help me to draft an answering affidavit?
I must refuse and say, no, I can't do it.
But I mean, is that a sensible thing?
Of course, it's nonsensical, to say the least. There's no justification for that, and I can't. It's a colleague to my supervisor. She's asking for assistance within, which is lawful, and then within my work environment, and they're like, how do you do that?
Yes.
I can tell you now that even in the past 7 years that Advocate Shamila Bato has been here, she has never finalized the affidavits and all those things by herself without anyone assisting her. It just doesn't work that way.
Yes. And then the only way then to justify this charge is this catch-all, no evidence.
Yeah.
But as soon as you cross that line, that's the end of this charge.
Indeed.
Yes.
Yeah, Advocate. Still on this issue of the council that were appointed to deal with this matter, to oppose the review application. The brief to council, who issued the brief to council? Is it the office of the NDPP or is it the office of the
State
DPP?
No, it will be the office of the NDPP through the state attorney.
And that makes it clear as to who is actually opposing the review application.
Indeed.
Thank you.
Yes. Thank you. And then 3.1.1.4 says you instituted an appeal against the judgment of Judge Govenor without the approval of the then National Director of Public Prosecutions, Mr. Mdluli. We've dealt with the catch-all, no evidence.
Yeah.
I just want to get the facts straight around how this appeal story unfold.
But what had happened, it's a decision that the Govenor J has made. It's given to the prosecutors to say this is what this was happening. The prosecutors looked at the decision, and then they said, no, look, in view of this, we cannot appeal because we are being told that there is a concession that was made by Mr. Hodes. They sent me that view of them. I take that view, I send it to Mr. Lawrence Hodes to say this is the view of the prosecution team. What is your view? And Lawrence Hodes says, no, look, let's have a meeting with the prosecution team because there is nothing like that I had considered. And now, Advocate Mayema, the lead prosecutor, like indicated, after the discussions with council, it was decided no, an approach must be made for the NDPP to file to appeal this ruling by Govenor J. Now the dais is running, and I was requested to brief Advocate Dr. Ramaite to say this. We have got this scenario. Can we get the approval from the NDPP for the latter to authorize the the filing of the appeal. Of course, it was taking some time that Advocate Ramaite did not come back to me to confirm whether and then the dice was running. And counsel advised to say, look, what we should do is we can file provisionally so that we don't have to do condemnations and all sort of things. And then again, the event that the NDPP approves, then we'll proceed. If he withdraws, then he will withdraw. And then indeed, that's what has happened. But unfortunately, Advocate Dr. Ramaite omitted to timelessly brief the NDPP, and it came out in the press, and then Mr. Ngcukaitobi saw it in the press that the NDPP NPA is appealing the Govenor judgment. Of course, he became unhappy and not appreciating that this kind of a decision would have been taken without his knowledge or approval. Consequence to that, we were called to a meeting between me, the prosecutor, I think it was Advocate Maema, and Matenjwa, and the NDPP with his advisors, and Dr. Ramaite. And in that meeting, Dr. Ramaite acknowledged to say, apologized to say, no, look, indeed I was I advised that I should brief you timelessly with the documents to say this is what should happen in view of the Govenor judgment and the like. Of course, Mr. Ngcukaitobi then indicated his unhappiness about that, and then he said he accepts the apology from Dr. Ramaite, but he has decided that there should not be an appeal, and then instructed me that I should inform the state attorney to withdraw the appeal accordingly. And that's exactly what I did. After the meeting, I sent the email to the state attorney to say the NDPP has decided not to appeal, and that the appeal should be withdrawn.
You see, because Mr. Maema confirmed exactly what you're saying, that actually the decision was that of the prosecution team.
Yeah.
And it had to be filed with some urgency because of the time limits.
Yeah.
And then when it was decided not to proceed with it, it was withdrawn.
Yeah.
But more importantly, for your purposes, the person who you would have undermined, quote unquote, by appealing without their consent is Mr. Ngcukaitobi.
Yeah.
What was his view about this? Did he think, well, this is now a big misconduct charge, I should now go after?
No, you would know if needs be, probably, if time allows, he will come and testify, or he will send a statement to indicate that he is even surprised that that has been made to be a charge which relates to him, and this was not even discussed with him.
Yes.
I can say for a fact that he's surprised, even as I'm sitting here, he's surprised that there is that kind of a charge that relates to him, and he has never even been consulted.
Yes. I mean, if he thought there was a misconduct problem, he would have instituted charges back then in 2012.
Indeed.
Through you, does this now suggest that Advocate Ngcukaitobi is the appropriate person to can talk about whether it was you in some way or the other constituted misconduct, or your actions constituted misconduct by pursuing the
Appeal.
or instituting the notice of appeal? It was not even pursuing the appeal, but instituting that notice of appeal.
No, indeed, Chair. That's what I'm saying, as a matter of fact, because when he saw this, and when I approached him, then he was surprised, and then he said, "How can the NPA and the DPP do something like this without even consulting me?" As if I am the one who's complaining that this is what Chauke and the prosecutor's team have done.
Yes. And then it's the usual story, no charges. no justification for the charges. And then the last one under Kaitoman is attempted to have racketeering charges against Major General Boyson and members of the Kaitoman unit reinstated by the then National Director of Public Prosecution, Mr. Nxasan. So let's just stop there. What does this mean that you attempted to have these charges reinstated?
Chair, on the record, what has happened after when that meeting that I referred to where Nxasan issued an instruction to withdraw the appeal, he immediately set up a date to say he wants to have a full briefing of the matter because he did not have the background and all sort of things and the like. And the matter, the date was arranged, I think the 20, I'll get the actual date on the statement, but it was, I think, 7 days or 14 days after the date when we met about him withdrawing the appeal. And in that meeting, the prosecution team, Mayema and Matenja, they were doing the presentation. In that meeting, Advocate Nogo was also invited to be present in that meeting. And that's where in that meeting where he said, okay, I understand, you guys go and find more because the judgment does not say we cannot reissue this statement. And he made even reference also to a signed statement of Danikas, and they like to say once you are ready and you have got more, bring the application. I will consider it. I understand that meeting is the one that is said to be an influence for him to consider a reissuing of the racketeering. Other than that, where it's coming from, I really do not know. But I can tell you now that Mr. Nxasan is also surprised that there is this allegation that there was an attempt, a subtle attempt or with a malafide that he was supposed to issue a racketeering certificate. Which is not.
The actual evidence we have so far, even if you forget about Mr. Nxasan for a moment, is from Mr. Mayema, who says that his view remained throughout the tenure of Mr. Nxasan and the tenure of Mr. Abrams, that these charges should never have been withdrawn, they should be reinstated.
Yes.
And he motivated to Mr. Nxasan to reinstate the charges.
Yes.
And Mr. Nxasan felt that there were certain evidentiary gaps to be filled.
Yeah. But when that motivation was done, the second motivation, I was not there. The meeting that I attended, yes, in which Nxasan said, no, from now on, Chauke, because Nogo is not as conflicted as a predecessor, you must now stop being the coordinator. Nogo should,
yes, and that was in April 2014.
Yeah, that's when that was the period of that the appeal and what have you.
Yes.
So like Advocate Mayema said, he did this presentation and then he was they were told to go and find more. They went to go and find more, and then they did the presentation to Mr. Nxasan, but he was still not satisfied. They had all those queries and whatever. So the reality is, Advocate Mayema would have been the one who would have went back to consider that this the case should be re-enrolled and the like.
Yes. Well, I mean,
just coming in here, that portion of the evidence, it is correct that also Advocate Nxasan,
Yes.
I beg your pardon, attorney
Mr. Nxasan.
Yes, Mr. Nxasan. Mr. Nxasan made it clear at some point that he is conflicted.
Yes.
And that could have been also part of the delay. He's conflicted in respect of the Katomena case.
Yeah, he said
because of his relationship.
Yeah, he said to some of whether were the victims of the accused that he would have they would have been his client or something to that effect. But like Advocate Mayema had explained, there was something like that, and then he had indicated ultimately I might have to delegate the issuing the authorization of this to one of my deputies.
Yes, but I'm just saying the reason advanced according to the evidence that is now on record.
Yes.
is that he had a relationship, be it business relationship, working relationship, whatever, but the relationship with some of the Katumena officials.
Yeah, some of
unit
the West
officials.
clients, I cannot
That's
remember
right.
whether
Yeah.
it was the officers or the victims in
Yeah.
respect of, but
Yeah.
something to that effect.
Okay, thank you.
Thank you.
Okay, Ngcukaitobi, I know that you have now exhausted the terms and the
Katumena.
rubric of
Yes.
Katumena matter.
Yes.
Shouldn't we pause here? It's 5 to 8. It's late
Indeed.
in the hour. We are not going to sleep here. I hope I didn't interrupt your
No, this is the right time.
clarification. I think we should pause Advocate Chauke until tomorrow morning at 9 o'clock.
Thank you, Chair.
And I suppose, Advocate Ngcukaitobi, we will run to finish with the witness tomorrow.
Madam Chair, I think we've done 60% of the job today, so we could even have a short day tomorrow.
Can I rely on that undertaking?
No, I don't rely. No more public undertakings.
Yes, thank you very much. Sorry we kept you until late in the hour, but we've made some progress. Advocate Chauke, you remain under oath and you will continue tomorrow morning at 9 o'clock.
Thank you, Chair. I do
Thank
confirm.
you. We'll adjourn.